Yes.
Okay. Well, good afternoon, everyone. Before we dive into today's discussion, I want to take a moment to offer a heartfelt thank you to the Rules Committee of the Family Law Trial Division. It's Judge Gloria Lopez, Judge Janice Berg, and Judge Jermaine Tanner. All of your time, attention, and detail and deep understanding of the daily realities of family law practice are evident through these new rules. You've all taken into consideration the family law practitioner in reviewing and revising these rules, and we sincerely appreciate it. I also want to extend appreciation to the entire Board of Family Law Judges in Harris County, adopting a unified set of rules that reflects both consistency and judicial discretion is no small task. And at the bench's collective commitment to fairness, transparency, and courtroom efficiency will benefit our entire legal community. So on behalf of the HBA Family Law Section, we thank you for your service and leadership, and we are grateful for your continued partnership and for the clarity of these new rules, and we will use to work toward better outcomes for the families that we serve. So we sincerely appreciate that. And also, before we get started into the meat of our presentation, we wanted to start off with a pulse check because these rules have not been changed since 2003. We thought it would be prudent to ask, and you can be honest because this poll is anonymous. When was the last time you actually read the local rules? So you all can take this opportunity to put in your vote for this. And we'll monitor the poll and let you all know. Okay, so we'll get started with the actual rules themselves. And I wanted to pose the question to you all. As you went through these rules, which rule rule or section would you say reflects that has the most significant change from the prior version of the rule? Judge Lopez, you want to get started?
Sure. In my opinion, the most significant change would be Rule 3.4. I think Rule 3.4 reflects more of a meaningful change that affects us as practitioners on a daily basis. This specific section governs the trial dockets and was amended to accurately reflect the current practice that Family Law Trial Division has been doing and practicing. The previous version described more of a 2-week trial docket rotation that my presumption was adopted or structured around the civil trial division, which is not exactly what we practice, right? So it was an important thing for us, not only as a division as a whole, but specifically the Rules Committee, for us to move away from outdated language that didn't mirror exactly what we practiced every day.
And I would have to agree with that. There were a couple of changes made under Rule 3.4, not only with the trials, but how we handle certain judgments before the court, like the default judgments and judgments from agreed prove-ups and that sort of thing. And so we just wanted something that would reflect the way we are currently practicing and have been for at least during the time period that we've been on the bench.
I'd like to add, as a practitioner, I do appreciate the change from having an order over to opposing counsel from 7 days to 5 days. That extra 2 days is actually really practical in our practice. So I do appreciate that that change. I noticed that when I was reading these rules. What about rules 4 and 5? Were there any changes to those rules that you all saw as being significant from the previous rules?
So substantively, they aren't that different. Rule 4 was really sort of a word salad that went over things you should provide before trial, things that you should disclose once a case is filed. And when you read it and mapped it out, it made very little sense. We've structured it now into two separate rules, one that deals with disclosures that occur at the beginning of a case, and then Rule 5, which deals with required documents to exchange before your hearings and your trials. That, I think, has made it much more clear which is which. And although they overlap, I think that they overlap in terms of the information that may be disclosed or exchanged. It's now laid out in a way that makes sense and where you can read them separately instead of trying to figure out which portion we're really focused on. Is this a document that we should have exchanged at the beginning or a document we should exchange before trial? I know there's some similarities perhaps with the previous disclosure rules that we had and that then were repealed with the enactment of Title VI of the Family Code. But if you looked at the local rules, you'd see that those disclosures really had been in our local rules for nearly 20 years. They were always there. And so we are not reinstituting the repealed laws. We have just simply clarified and put in plain English what we've already had. So it looks different, but it isn't substantively all that different.
I agree. And I think so many individuals had a reaction that it was something new and that the Harris County Family Law Division was now bringing back mandatory disclosures. But I think that a lot of us had forgotten what has been there for over 20 years. And this was a great opportunity to remind us that they've always been there. And let's draft them in a way that they read clearer and that they are helpful, not only when you're reading them, but practically when you're applying them in your cases. When you read Rule 4 and 5, I think it's important to note that we did add something substantive, which is your classic mandatory exclusion, right? The 193.6. So that is what is different in those rules, if you had to ask me specifically.
And I think that, when we're looking at the disclosures that we have under the local rules, it's important to note that those are like your bare minimum requirements that the court needs in order to make an informed decision. If you're not going to do anything else, at least do this. And this is the way that it needs to be done. Like that was the overall goal with how we approached what is now Rule 4 and 5 of the local rules. It wasn't at all intended to supplant the Texas Rules of Civil Procedure, obviously. You still have to follow that. But this just sort of gives a guide for the practitioner to get to and provide us with, and especially when we're talking about temporary orders and that sort of thing.
And so now we've talked a little bit about rules that have significant change, maybe not perhaps substantive, but significant change from the prior version. Are there rules as you guys were going through this process that lawyers may have overlooked that you anticipate will actually have a big practical impact on the practice?
It depends on the type of practice that you have, but I do think it's important to point out our last rule, which is the language access plan reference. There have been a lot of media stories recently about what the district and the Commissioner's Court has done to try to bring some language access in, and it's been a little confusing for some who come in and they say, well, I'm not sure. Is the court going to provide the interpreter? Is it free? And this really refers you to what we've determined as the Board of District Judges for the county that complies with our language access plan. And it should be clear when you go into court that you don't necessarily you shouldn't need a motion, but you do need to provide notice to the court if you do need an interpreter. And as the rule provides, that the assistance services that are provided may be free of charge, depending on the resources available. And at the same time, because of the rules of civil procedure, allocation of cost, general rules like Rule 183, the court can order one or more parties to bear the cost or to assess them generally as cost in the case. But since it's the last rule, I wanted to draw it to everyone's attention. And if anybody has questions and want to dive deep into the language access plan that the county has, that actually is available on justtext.net. And I encourage you to look at it to see what the possibilities are and what the courts have established as the proper rules to apply with limited access to English.
And if I can just add to that, and to be clear, it's not automatic that this will be something that's free to the litigant. I just had a case the other day where I assessed costs equally between the parties, but the good news was where we had, an interpreter that was unavailable for final trial on that day that had been prep set. We were fortunate enough to be able to have access to two interpreters that were able to appear and proceed with trial on that day. It's not always going to happen in that manner where you can, have access at the last minute, which is why we say that you have got to contact the court ahead of time so that we can be sure that those things are provided. But in this particular instance, it worked out. So it certainly needed to be added to the local rules because that's a significant change that has happened not only in our courts, but in our county. And it simply, wasn't in existence back in 2003 when the local rules were last addressed.
And the court has the availability or the, I guess it's a relationship that we have maybe by contract with Masterword and some other large organizations that provide every language that you could imagine. And so people who have come in and said, well, my client speaks Farsi. We don't have a Farsi interpreter. We're sort of going to see what we can do. We don't need to rely on that. We can now offer that service by contacting Masterword with enough time, requesting a Farsi interpreter or any language you can come up with. And they will have folks who are available and who can be qualified as interpreters just by simple, voir dire questions, either by the judge or by the attorney, to be sure that they're comfortable, you're comfortable that your client can understand the interpreter can understand your client.
I think on a different note, to answer the same question, what rule I think may be overlooked at times. I think Rule 6.5 and 6.6 can easily be overlooked because it discusses significant description of what should be included in your certificate of conference. What are the requirements that must be included in your certificate of conference on an opposed motion that you have set for either oral hearing or consideration by submission? And that rule 6.5 lays out exactly what must be contained within your certificate of conference. And once you read that, and then you move to 6.6, you will find that the court has the authority to decline to consider the opposed motion if you do not comply with 6.5. So you don't want to find yourself in a position where you have prepared significantly for this opposed motion and then find that the court will pass your setting. Certainly your motion won't be denied, right? It simply will not be considered. And now you put yourself in a position where yourself and your client have had an expectation, right? But the court passed it for your failure to comport with this rule. There,
Oh, sorry.
oh
Go
no,
ahead.
there were some questions in Q&A. There was
Oh,
questions
sure.
about where to locate the local rules, and they are located on the website justtext.net. It may not seem like it's an easy access, but if you go to justtext.net, there's an icon that lists local rules, and you'll find all the local rules for all the divisions, and the family local rules are located there. I've also attached them in the chat as an attachment for you guys to download and save for your file.
Having identified specifically rules 4 and 5 as being rules with significant change, let's take a minute to dive a little bit deeper into those changes and maybe the thoughts behind the revamping, not necessarily revamping, but revising of those rules. Looking at Rule 4, which covers disclosures, mandatory disclosures have been a part of the local rules for some time. What prompted the Rules Committee to revise and expand Rule 4 to what's now contained in the current version?
One of the reasons was for clarity. When I was reviewing these rules and trying to make updates to our Rule 4, I realized that I was going to need to start from scratch because it was confusing and the wording was, there were many unnecessary words, there were words that were missing. And one of the things I did was I looked at the surrounding county local rules to see what sorts of documents and how the surrounding county courts are laying out their rule to sort of bring some consistency with Harrison surrounding counties. Not all of the local rules look like this, but some of them do. I think it was also based on the experience that we've had as courts where, as Judge Tanner said, this is the bare minimum of what we need in order to do our jobs. And making this clear will hopefully make it easier and more efficient for you all to bring your cases to us and for us to have the information we need to make quick decisions for you.
So, oh, did you want to say something, Judge? One of the rules that changed, and it specifically that we thought was necessary under the disclosure is the exchange of documents under temporary orders. If you look at the prior rules from back in 2003 for temporary orders, it says at the beginning of the hearing. And I think that one of the issues that a lot of us judges have in a situation like that is that you have counsel that says, I just got these 5 minutes ago and I haven't had time to review these documents and we're not ready. And so to sort of combat that, we've added a time that it has to be done, right? And that time is the day before at 2 p.m. Now, I guess we can sort of talk about why 2 and not 4, or why 2 and not 5, but I think it just provides a baseline so that everybody understands that those documents need to be in before your temporary orders hearing by 2 p.m. I do want to note we have 322 people on this call, so I might be speaking to somebody when I say this. But when you make an argument, and if you make an argument in court and say that, Judge, this should be excluded because I got it at 4 o'clock and not 2 o'clock, I will tell you that we will still use the good cause standard that is, pretty much the standard under the Texas Rules of Civil Procedure in determining whether or not receiving those documents at 4 versus 2 o'clock is reasonable, in which most cases it's reasonable. But certainly there had to be some sort of time period set out in these rules for when these documents can be provided so that as practitioners, you could have, um, um, something to go by when you show up to your temporary orders hearing. and haven't been able to have access to those documents.
I think on that same note, many of you have a question as to conflicting information within the local rules and a court's policy and procedure as far as exchanging exhibits. And specifically, one of the questions in the Q&As asked, if a court has different exhibit exchange deadlines that are presently in the court's website, should lawyers or litigants disregard the court's exhibit exchange deadline and only use the local rules? So to answer that question, the local rules do not discuss exhibit exchange. If you read them carefully, I think it's clear that we're discussing document exchange. We are not addressing exhibit exchange. So I hope that clarifies that. So could that document that you received at 2 p.m. exchanged before a hearing for temporary orders be marked and used as an exhibit? Certainly. But that is not to remove a specific court's policy and procedure as to how they wish to receive your exhibits, your exhibit list, and how they've required you to exchange exhibits.
And so other than the problems surrounding the area, the topics that we've already discussed, were there any other recurring problems or compliance issues with the prior disclosures that you guys set out to extinguish with the revision of the rules?
Well, I found, I don't want to speak for anybody else, but I found that the compliance with the rules, our former local rules, was sporadic at best. And sometimes somebody would raise the local rules, but most of the time people wouldn't address the local rules and they would sort of by consent not exchange them. And then occasionally one person would pull out the local rules and say, aha, things X. And that was not practical and it was not sufficient. And it was creating, I think, some perceptions of unfairness. I think that what really drove this, and one of the things I had in mind was sort of reviving it and breathing some more air into the rules, that it would bring attention to the fact that we have them and that they need to be complied with, so that we have more of a culture in Harris County of complying with this rule. That's what I would say.
I agree with Judge Berg, and in reviving it, our intent was also to help you. So we're calling attention to this. We're adding some fresh blood to it, and let's help you by clarifying it, by making it read clearer and remove any ambiguity, right? So hopefully that continues, and that way people are more inclined to follow it.
And also, if I can add to that, because these are on the justtext.net website, and it is our bare minimum, it's easy for not only our lawyers to get to, but it's also easy for the self-represented litigants to get to, because our pro se parties aren't necessarily getting to the Texas Rules of Civil Procedure and understanding the nuances of discovery and those sorts of things. And so the local rules, how they're streamlined, the way they're worded, and where they're located makes it easy for everyone to be able to navigate their cases once they get into court, and what is required, so that we can make our decisions.
There's a question in the chat that kind of connects with what Judge Tanner just stated, and it's a very verbose question, so I'm just gonna paraphrase it. And it's discussing how some self-represented litigants have a difficulty with technical with technology or lack technology skills or access to certain programs to allow them to upload or download documents in a cloud or a drive, it would certainly can be seen as an obstruction of access to justice, right? And how the court can handle that. I think in our local rules, we don't mention any of that. That really, I can candidly say those are policies and procedures. And as policies and procedures, the court has discretion. And the ultimate goal is for everyone to have their day in court and feel as though they received access to justice and were heard on that day of court. And in order for us to facilitate that, there are certain things that as a judge, we can accommodate or make exceptions or provide an alternative for. However, sometimes we don't know it is a problem, right? And we have to be candid about that. We may have 1,200 cases. We don't know all 2,400 parties or that are before us. So my commentary to that statement or question is absolutely, like Rule 14, the language access plan, like many of our rules, the ultimate goal for lawyers in the private bar and self-represented litigants is for us as a court to provide all of you equal access to justice. And if there is an issue, you have to relay that to the court coordinator or file a motion for us to make a determination of how can I provide you an alternative within the bounds of the law.
So with all the changes to Rule 4 under the local rules, if you could bottom line of what do you want attorneys to take away as the most important change?
Judge López?
Follow them.
Seems so simple.
Follow them, and also do not be discouraged when you believe that you're backed up into a corner. Remember, ultimately, you have the authority to make an argument for the court or before the court about good cause or about the definition of reasonableness when it comes to supplementation. That is your job, not only as a lawyer, but as a person that, if you are a person that represents yourself, to do so. And I cannot unilaterally as a court make that decision if you haven't made the argument.
And we talked about disclosures. What about what's the court's expectation regarding disclosure of items that aren't specifically listed in 4.2 or 4.3, but also may be relevant to child support or property claims?
Well,
Oh,
Judge?
if you think that it's going to be relevant to your case or relevant to the court, so that an informed decision can be made, disclose it. I mean, it's really just that simple. It's a call that's made by the attorney that in addition to what we've named, if you think that there's something more that's going to assist the court and help your case, then follow the rules of disclosure, especially if you intend on using it as your evidence and or an exhibit. And so give it to the other side and let them see it and then proceed accordingly. But certainly this is a starter list of things that the court would need. But I think it would be applicable to anything that you deem relevant. And follow the rules based on that premise.
And for those who look at the list and say, well, that might not be enough in my case, because I also need 2 years worth of pay stubs. That in this case is going to show me all the money that was being squirreled away in a different 401k. Okay, so in that case, that's where you then file and serve your request for production. This
Mhm,
isn't going to cover everything.
mhm.
So I agree with Judge Tanner. When you're the person producing the documents, if you feel like it's relevant and important, go ahead and produce it or disclose it. And if, on the other hand, you're the person who's looking for the information, don't rely on this. File and sorry, not file, but serve your requests for disclosure. Sorry, your request for production, your interrogatories. Notice of deposition. All of those discovery rules that can be used on top of this, layered with this.
Correct. And I think on that same topic, the question and in a Q&A, they're asking whether the local rules are enforceable. And I think maybe a better word or phrase would be, can a party file a motion to compel for failing to follow, let's say, Rule 4, a mandatory disclosure?
Yes. I think the specifically provides for that. As far as the fact that the rule is signed by 4 judges, that doesn't mean that it doesn't apply to the entire family board. It does. This was signed by the members of the Rules Committee, the 3 of us, and it was signed by our administrative judge the time we signed it, Judge Graves Harrington. This speaks for all of the courts in the family board. So yes, it applies to all of the courts.
And then just real quickly, I wanted to talk about Rule 4.6 is the duty to supplement all of these things that we've been talking about. How strict will the courts be on ongoing supplementation? And then as an aside, or to dovetail into that question, will late supplementation risk sanctions or exclusion of evidence? And I'm just going to go ahead and throw in, and what consequences can lawyers realistically expect from the courts for these rules, for failure to comply with the rules?
So I think that, that's something that's handled on a case-by-case basis. We understand what the Texas Rules of Civil Procedure says regarding, supplementing 30 days before trial. However, the court also recognizes that there are certain circumstances where that is not possible. And so the attorneys know that all you have to do is make your argument as to why you did not have it in the manner that's prescribed by the rules, and let the court decide whether or not that is an acceptable argument to allow those documents in. But I mean, we understand that, especially when you have document heavy cases, which would typically be your property cases, that it might be at times, and I'm being very careful when I word this, it might be difficult at times to have things in the manner that's prescribed, but you make your argument and you allow for the court to determine whether or not, when it was received by the other party, reasonable.
I'd like to point out something that I think those who practiced in front of me have heard from me before. Keep in mind that supplementation is a duty. It is not a right. So when people say, well, I had the right to supplement, remember that the rules of supplementation, as defined in our rules of civil procedure, gives you the duty to supplement when there is something that is new or something that you knew at the time that has changed and you need to update it. It's not a reason to avoid producing something simply because you have the right to supplement. It is a duty. And so remember that when it comes to reasonably supplementing something after a trial is reset, let's say you've done your disclosures, you've done your pretrial documents, things are mostly the same, but your client has gotten a huge raise and the pay stubs would show that. Well, the duty to supplement kicks in there. I think that's sort of a no-brainer. And don't wait till the last minute and say, I had the right to give it to you at the last minute, because my supplementation right continues until 30 days before trial.
I think I have a good question as to Rule 6. Specifically, they're requesting us to discuss Rule 6.2. And it's in regards to requiring a written response to a motion as applying to, and it's they are asking, is it this applying to all motions, including motions that are set for an oral hearing? Or is the intention behind Rule 6.2 to apply solely to submission hearings? And the answer is to all motions, oral, or set for oral hearing or for consideration by submission. Some of us haven't practiced in civil court, but this is a norm in civil. If you are set for an oral argument before the court on a motion, it is understood that you will file a response to that motion or even a reply to the response prior to your oral argument before that bench. And when you don't, the court is safe to assume that there is no opposition to the motion. Another question that everybody is asking is based upon our effective date, May 1st of 2025, and how this applies to pending cases. So Judge Tanner, do you want to answer that question?
Well, so May 1st, 2025 is our effective date for cases filed on or after that date. Okay. I think that's the general rule that everybody needs to understand. Whether or not it falls outside of that, and you think that there's an argument that needs to be made in regards to something outside of what I've just said, that is certainly your right to make that argument to the court, and let the court figure out whether or not it's applicable to cases that were filed before May the 1st. But as a general rule, May 1 starts the time period for these local rules in regards to cases filed on or after that date.
Well, I think before moving on to Rule 5, I was going to do another poll after finishing up this disclosure. Who thought the Harris County local rules were just policies and procedures up until this presentation and or the announcement of the new rules? Oh, here's the result. Oh, of the new rules being published on May 1st. I will make mine not anonymous and say guilty as charged based on conversations just this morning. Okay, so digging a little bit deeper into Rule 5, the required document exchange before hearings and trials. Let's talk a little bit about the temporary orders. Under Rule 5.1, it lays out a detailed list of financial documents that must be exchanged by 2 p.m. Why that specific timing? I think we touched a little bit on this, but if you just want to revisit this just briefly, and how strictly will the courts enforce that?
Judge López?
How strictly will the courts enforce it? I mean, the blanket answer is always we are going to enforce the law and the rules. What your argument is to the court at that time is what we have to consider, right? So we did address it before. Was there an argument of good cause? Is there an argument that there is no surprise? There would be no prejudice? All of these things still apply, guys. And I say that because what many people are confusing is that, again, as we've already stated, this is a baseline. Do not forget, you still have the Texas Rules of Civil Procedure. We still have the Texas Family Code. There are many questions posed in the Q&A asking, well, the local rules do not address this. They do not address status divorces. They do not address depositions. Well, they don't, but the Texas Rules of Civil Procedure do, and the Texas Family Code does. So don't forget that you still have all those other statutes that are going to be helpful in your arguments and presentation to the court.
And in practice, what happens when a party fails to timely exchange the required documents before a temporary order hearing? Will the court continue the hearing, impose sanctions, or proceed without the late party's evidence? And to add to that, how should an attorney handle these situations where one party complies with the rule and the other party doesn't? What's that expectation from the court?
I want to hear the argument as to why there isn't a compliance. Again, the Texas Rules of Civil Procedure still apply. And it's not going to stop me from moving forward with the temporary orders hearing. But certainly, when you're before the court, you have the ability to make your arguments as to why or why not you've done what you are supposed to do, according to these rules.
If I understand the question correctly, it's what can you do if somebody has failed to follow the local rules and failed to produce documents, right? And luckily now the local rules have the inclusion of Texas Rules Civil Procedure 193.6. So it is clear that you have the authority and the ability to make an objection that they should be excluded for failure to produce or to exchange, right? And then let's not forget Part B of that same rule that discusses what is the burden to establish the exception for that mandatory exclusion that we discussed before. The burden of establishing or arguing to the court that good cause exists, right? That these documents should come in, or that there is a lack of unfair prejudice or surprise to the other side. So to answer your question, the court's going to follow the local rules and Texas Rules Civil Procedure. And it's all based upon your argument.
Anyone else have anything on that?
I agree with my colleagues.
Okay. And so looking at final trials, which is covered under Rule 5.2 under the newsletter rules, this is the rule that contains a 10-day exchange rule for final trial materials. What prompted the specific timeline, and how does it affect pretrial preparation and court efficiency?
Well, I think the prior local rules said that in sort of an unclear way, it gave sort of 10-day, we sort of called them 10-day documents when I was practicing. And these are your sort of pre-trial documents that you're creating. So they're not discovery responses. You wouldn't include it in discovery. And that seemed like, I thought that it seemed like a reasonable amount of time. Your 10 days before trial, this is when you can expect to receive and send over your suggested relief. I think it seemed like a reasonable time frame, and I'm not sure whether there is another reasoning that you ladies would suggest. Sort of carrying it over from before with this concept of the 10-day documents.
We were trying to not stress or overstress everybody. While our intent is to amend and clean up the local rules, we're not going to come in and just create new rules that you're not used to, and you have to readjust your practice and change your timelines and change the way that you litigate. So we're trying to also, while we're trying to streamline and clarify, we certainly don't have the intent to create more chaos and stress.
You know, another change that might be important here to note is that the rule used to say that you had to file your inventory and appraisement 10 days before trial, and that you had to exchange it before trial. But one of the things that was really tricky, and I think tripping some people up, was you have to file your inventory 10 days before trial. And people then would rely on their inventory having been filed as though the court can use that as evidence when it's dividing the estate. And we've been told by the courts of appeals numerous times on the regular that the court can't take judicial notice of the inventory and appraisement that's in the file when it's making its decision on a default, for example. And we took out the requirement to file really, I would think primarily because we didn't want people to think that filing it got it into evidence, or that not filing it kept it out. I wanted to point that out because I think it's important. We still have to tell people, our associate judges, all of us have to tell people, we can't take judicial notice of the inventory and appraisement and rely on that. That is not evidence for us. And so we did remove the requirement that it be filed.
I think on that same note, we have the Texas Rules of Evidence that address what is admissible and how it's admissible into evidence. So a question posed was, the Rule 5 documents that are exchanged, are they automatically admissible into evidence? And the answer is no. I don't know, one, if they're going to be offered. Two, if there's going to be any other objection that I have to consider. So while maybe there is a valid argument as to authentication, right? Because they were produced by the other side, that's valid. What are they automatically admissible into evidence? I think I feel comfortable enough saying the answer is no.
And most of the 5.2.2 documents are what we would otherwise introduce and admit as a shorthand rendition of testimony. So think of it that way as well. And we're not necessarily introducing or admitting a child support finding as evidence of the resources. We're using it to typically for a witness to say, this is what I've worked out based on the numbers I've been given.
And in what circumstances, if any, might the court excuse or extend the 10-day deadline for trial materials? And should practitioners seek leave in advance, or is late supplementation ever tolerated? And what about attorney rule 11s around this? How do you guys feel about that?
I love a good rule 11. I think if you and your opposing counsel can agree to your own deadlines that work for you and work for your case, by all means, you can decide whatever you want to decide by Rule 11. File that if you need to enforce it. I can't remember the rest of the question. I got too excited when I heard about the rule.
Sorry.
I love me a really great motion for leave. I think it's they're appropriate. They tend to be very candid about, here is the situation, Your Honor. It's not within the time period, or it's not within what the statute states, and here's why I'm asking for leave. I think very few practitioners use those, and they can be a really great tool, especially when you have not only the TRCP, the Texas Family Code, and now your local rules. You can use that to get out of a situation that you may find may harm your client or put your client's case in a detrimental position if you do not ask for leave.
And I think it's important to know that you can't be afraid to ask. Just ask. The court will consider it. Doesn't mean you'll get what you want, but you never know. I can guarantee that if you don't ask, you won't get. So, don't be afraid to file your appropriate motions, like Judge Lopez said, for leave. And let the court consider whatever it is that you have to argue as to non-compliance, and see what the court says. We have that leeway here. And we have the discretion. And so it's just a matter of putting it out there and allowing for us to consider it.
And I want to touch briefly on supplementation in resets of cases. We're nearing that 1 o'clock hour, so I wanted to kind of get through some of this other stuff. But Rule 5.4 imposes a duty of supplement if a trial is reset. How often do courts see parties show up at reset trials with outdated or unrefreshed materials? How will you all handle this going forward, and where does your tolerance level on that?
We're here as the referees and the person that's trying to get you all to your resolution. If that's how you present your case, I don't know if it's for me to really be upset about there not being a supplement to documents that you had before the reset trial in this matter. If what I'm given is what I'm given, a decision will be made based on what I have. So this is more so an attorney style type of question. I would certainly think that if you want the court to have updated information to make an accurate and appropriate on-time decision, then you'll supplement.
And this rule also says that failures to comply may trigger sanctions under 215 or exclusion of evidence under 193.6. And I know that the general response to this has been it's a case-by-case basis, but you'll entertain these as consequences to failure to supplement timely, and that you guys would, depending on the circumstance, strictly adhere to some sanctions if necessary. Does anybody else have anything to add to that? I think that was a pretty common theme throughout. So I was just going to ask, is a general wrap-up question, how do the local rules balance the need for uniformity across the courts with also giving individual judicial discretion to each of the judges in their courtrooms?
Judge Lopez, you want to tackle that?
Sure. Like we previously stated, the local rules are a baseline, and a great example of how a lot of these Q&A questions are discussing very specific scenarios. We're trying to create a very uniform or create a bit of consistency, not only for the private bar, for all constituents of Harris County that practice before us. So that way people don't feel like we're hiding the ball. The goal is not to make your life more difficult. And I've been hearing for many years now that uniformity is helpful and it's desired. And I understand that. In fact, the entire board understands that. And this is our step to help do that for everybody. But also taking into consideration that we're not going to remove and micromanage how a specific judge, for example, how Judge Berg analyzes and processes what an argument should be. right? That's an impossibility. That still gives Judge Berg that authority and that discretion to hear your argument, process it, analyze it, and rule in the way that she finds to be correct for that case. But the baseline, your starting mark, your local rules, we're trying to help you. What we're trying to say is we hear you. They needed it to be updated and you desire uniformity and we're working on it.
Certainly appreciate it. We certainly appreciate it as the practitioners in y'all's courtrooms. Is there anything else that anyone wanted to add before we close out today?
Yes, the course ID will be sent on the chat as well. So before you log off, I will be including that there. I again want to thank not only the members of the Rule Committee for their hard work and dedication to get this done. They and only they know how difficult this was and how much work it took. Eileen Gaffney, our staff attorney, that was resourceful and essential to getting these drafted and passed as well. But the entire board, I'm appreciative of their support and their input, and Judge Graves Harrington as our leader during this time that helped us finally change and update these rules. And I know we thanked them before, but I want to thank them again because without this entire cohort, you wouldn't have this before you today.
We certainly appreciate it.
So let me include this for everyone, the course number, and that way you can have it to self-report your 1 hour credit with the state bar.
Do you have the poll results?
I
I'm
do.
just curious. I want to just curious how many people are out there in my boat.
So this is the poll result for question number 2.
Oh man.
There's a lot of humble braggers out there.
Yeah,
I like it.
Maybe
And
not so humble.
that's all right. And let's share the results for the first poll.
Lots of humble braggers.
I love the
great.
12%.
I identify.
I like people who are scared to show up unprepared. I want to thank you, Judge Lopez, Judge Tanner, and all of the folks that you previously thanked Judge Lopez. And we also appreciate the bar's patience as we roll this out.
Absolutely. And then, and you know, as Judge Lopez said, thank you immensely to Judge Graves Harrington for putting us together and trusting us to get this done.